Good morning, good afternoon, and good evening from NISSMAT. I welcome you to the second episode in our series of podcasts on combating counterfeiting and brand infringements. I'm your host, Pavanjit Aluwalia. NISSMAT stands for the National Institute of Security, Safety, Management and Applied Technology. It has four wings: the Forum, the Academy, Enterprise, and the Foundation. Please do like, share, and subscribe to the NISSMAT channel. Joining me for the podcast is the president of NISSMAT, Mr. Sipal Singh. He has had decades of practical experience in combating counterfeiting and brand infringement. Mr. Sipal Singh is the president of NISSMAT, a former IG Police, and the Director of Brand Protection Associates. In our first episode, we spoke of what was intellectual property right and the various acts regulated in India to provide protection to creativity and innovation. Intellectual property right is a transnational problem and causes loss both to the government and the consumers. We also spoke of how the Copyright Act protected artistic work and the role of Trademarks Act in protecting brands. I start today by asking Mr. Sipal Singh if you could kindly clarify for us the distinction between criminal and civil law, especially in terms of intention. How does the requirement of intention in criminal law set it apart from civil law? Mr. Sipal Singh.
Thank you very much, Ms. Pavanjit Aluwalia. Your first question, that what is the difference between criminal law and civil law, is important, particularly from the point of view of dealing with infringement and counterfeit products. In criminal law, there must be intention on the part of the person doing the act of infringement. In civil law, the act done may be accidental and not with the intention, but it results in counterfeiting. In criminal law, again, the harm done is public as well as private. In civil cases, harm done is normally private. In civil cases, the plaintiff may be the state or any individual. But in the case of criminal cases, the plaintiff must be the state, that is the police authorities and the police prosecuting agencies. This is the difference between the criminal law and the civil law. The concept of harm, according to law, is any injury or act done to an individual or to the society which can be punishable under the framework of law. That is the basic principle of harm. Now, the definition of harm as such is not abundantly provided in the Indian Penal Code. However, Section 268 of the IPC defines an act. And in that case, it says an act where it also mentions harm, danger, annoyance to the public or people will be considered as a harm. Now, the harm definition is given that way, indirect definition. I mean, not directly given what is, but 268 of Indian Penal Code defines harm as such, that is danger, annoyance, or intimidation done to the public or people, and which is considered as harm. And various sections of basic law and specific law like Copyright Act also recognize this state of harm. So that is the basic definition of harm, and that is the basic definition between the civil law and the criminal law.
You mentioned a very interesting thing on harm. I want to just ask you, what is the significance of intention leading to harm? That is both public and private, and how does it compare to harm addressed by civil law?
Yes, you see, I said that is a criminal law. 268 IPC is a criminal law. It gives a little bit definition of harm. But basically, I have told you the harm is considered to be anything which causes annoyance, injury, or the other person gets some harm, some injury, or some mental harm done, or some physical harm, or in the case of counterfeiting done. So under that umbrella of the harm, you can cover this, counterfeiting, etc. But as such, it obviously means that anything which is done by an individual, and that individual does it only in the case of one individual, and the intention is not to cheat the society as large, then it comes basically in the civil laws. But however, in case the society at large is also getting affected, then the harm done is also public. So in that case, it comes under the criminal law. So in the civil law, it can be individual harm, but in the criminal law, it has to be a harm to the individual as well as to the society or public at large.
Very interesting. Majority of the times, people know the law, but they don't know how to comply with the law. And so my question to you is, what are the steps involved in filing a criminal complaint and leading evidence in court against counterfeiting? How do you go about complying with the law to sort of bring about a judgment in favor of your complaint?
I have already explained to you the difference between the criminal and the civil cases in law in the case of counterfeiting. Now, how do criminal laws in counterfeits specifically indicate the intention or defraud? I have said earlier in the first episode, I referred to certain section of the IPC also, where it comes to cheating. That was the basic law, that is Indian Penal Code. But that law is also used when we are filing cases of criminal cases in counterfeiting, where specifically indicating the intention to defraud or cause harm to the manufacturer and the dealers. Let us say you want to file a criminal case. You want a civil case, that also I'll deal. But first, let us say that you want to file a criminal case and a criminal complaint in the case of brand infringement or counterfeiting. Now, for that criminal complaint to file, you have to follow certain steps. First of all, you have to file a complaint. I mean, any individual will file a complaint in the police station. That a criminal law basically says that you have to go to a police station. He goes to the police station and he files a complaint. I in the first episode explained that by and large, certain enforcing agencies which are engaged by the manufacturers who are being cheated, these enforcing agencies can be private agencies also, private brand protection investigating agencies also. They can recruit them and they can work for them. But basically, whosoever has done, whether you have done as an agency or the manufacturer himself is aggrieved and he knows that this product is lying such and such place, somebody has to go to the police station to file a complaint. Now, presuming it is an agency, the agency investigates. It follows certain steps which are indicated in the first episode, A, B, C. How do you go about in finding out that duplicate products are stored there? How do you reply the decoy customer? How do you bring the notary, etc., which we explained in the first episode. Now, my point is the filing of the criminal complaint from where case starts. So, filing of the criminal case is there in the police station. But what the agency does, the agency after investigation files a GD entry, a general diary report, that this man is having product and he is having this thing. I have got sufficient evidence. Here is the evidence. Here is the notary's report. Here is my evidence. To the police station, and the police station concerned takes cognizance of that complaint. And after taking cognizance of the complaint, police also conducts its own investigation and to ascertain also the investigation which you have conducted. On the basis of those investigations and the records which have come during the course of investigation, the evidence which has come during the course of evidence and in the course of investigation, on the basis of that evidence, the police itself or the police prosecutor inspector, PI, whosoever agency is there, it files a case in the competent court of law. So supposing the police has arrested alleged accused, the police will take the accused to the court of law and either get a remand for a period of 6-7 days or 3 days to get further investigation by questioning that particular accused. The second step, that accused has been investigated by the police earlier. Further investigation of the police from the accused will be done when he is already in the custody, either judicial or in the police custody. Or he may not be in the custody. Supposing that accused has run away. At the same time, the evidence has been filed by us through the police, and they say, all right, you go ahead and conduct the investigation. So the second stage is the leading evidence in the court with reference to the infringement done will be produced by the police or police prosecutor in the court of law. And an application can also be filed under the Criminal Procedure Code for issue of search and seizure simultaneously. Okay, during our investigation, the first investigation, we found so product there and we have brought on record. But during the course of investigation, we find there are a number of other collateral people who are dealing with us. So we want to have search and seizures of these places. Then the police gets warrants, orders, search and seizure from the court. After that, further evidence is filed. The accused also produces his own defense lawyer. Case goes on until he is convicted or acquitted by the court of law. So it is A to Z. The entire process should be known either to the, basically to the investigation agency, if not at least the manufacturer or the person who has been harmed. In terms of infringement, he should know the process, because if you fall short of the process in a criminal case, your case is gone. So that is the way evidence is that.
Just to go back into the first part of the question, you first require a complainant who goes to the police station to file a complaint. Based on the complaint, the police mobilizes itself and goes to the site where the spurious product is lying and carries out a raid on that place and seizes the products that are in infringement, and they bring the products back into the police station, and thereafter the FIR is lodged.
You see, here there's a little.
Is that correct? The FIR is lodged after the police has seized the infringing goods.
No. You see, there's two ways to look at it. If the police has seized the infringed good, this is sort of evidence, authenticated evidence with the police on the basis of complaint filed by you, and hence they file an FIR. FIR can be filed even without anything, because it depends on what is the police assessment of the case. Once the police has been filed the GD entry by you or by the manufacturer, it is the duty of the police to get further investigation done. The FIR is only a first information report to be filed. After that, number of other evidences can be collected. This is a first information report not first information report by the individual, with the agency, but first information report written by the police, which also is given to the area magistrate. Probably people don't know why the people insist for FIR, because once FIR is filed, this FIR, every evening the number of FIR goes to the area magistrate. So therefore it becomes semi-judicial. Now the process has not started. The very fact that you have filed an FIR, this FIR will go to the area magistrate or area court. So if you withdraw the FIR, then you have to go to the court and no, I don't want to further. Police has to say, we don't want to further, and they file what is called the final report, FR. That is FIR. After that, they say, no, there's nothing. Then the other case is dropped. That is FR, final report, and then they withdraw the case. After FIR, the case will come to a charge sheet. That charge sheet has to be filed by the police in the relevant court of law, whereby the case actually evidence starts the case.
So there's a period in which they must complete their investigation. What is that period?
What? I'm not clear. What is the question?
There is a certain time in which the police must file the charge sheet.
Yes.
So it's 90 days and another further period of 90 days.
That is again a very ticklish question. Is Criminal Procedure Code lays down that once you file the FIR, within 90 days, you must file the charge sheet. That means FIR is filed. It goes to the concerned area court that this is case FIR number so-and-so against ABC is there with us. Then they say in 90 days of filing that FIR, when it goes to the area magistrate, when you said this FIR has been filed, in 90 days you must have sufficient evidence so as to file a charge sheet in the relevant court for conviction. But invariably, in 90 days it's not possible. So they extend it. All right, go with another 6 months or 3 months. Sometime after filing the FIR, you take 2 months, 3 months, 5 months. FIR still continues to remain active because you go on giving day-to-day intimation that we have not yet been able to come to a case where evidence is sufficient to file a charge sheet. So my submission is that in our cases, in these cases we are discussing in counterfeiting, within a period of a month or two after the FIR, sufficient evidence is available. Where some evidence has been collected by the investigating agency, some evidence has been collected by the police, and over and above the infringed product is the main evidence which is probably available with them. And over and above, when we went for seizure to a particular place, there you get panchnama prepared. Then the medicine, when this particular product comes to the police station, they get a panchnama. A, B, C people are here. Before them, we are having this panchnama. This thing has been caught from so-and-so person. So this is sufficient evidence. So within the next few days, we get some more evidence, or the police is able to collect some more evidence and files the charge sheet. But it all depends on the police investigation and police satisfaction that this accused is there. I'm talking about genuine thing, the way the law should go.
There've also been, instances where information from the law enforcement agency has leaked out to the people who are infringing the products. And when the police lands up there, the products are genuine and not. So there's a fair amount of leakage. Is there leakage of information from the law enforcement agencies or even from the courts?
Law enforcing agency is only the police. You say investigating agency. When you use law enforcing enforcing is only the police. Law enforcing is no other agency. Other private agencies are, they are only investigating agency for the manufacturer. So it is for the investigating agency of that whom the manufacturer is authorized, and the police has sufficient evidence to see, all right, he is not a person who has just come as a sort of spurious person. He has got no knowledge, and knowledge is gone. But the manufacturer has given him authority that yes, you investigate for our behalf, and you are requested also to make liaison with the police and file GD entry or entry a report to the police. So after that, sufficient evidence is given by the so-called private investigation agency to the police, and therefore the police induct immediately some more seizure. If you have not done seizure, you have only done the decoy customer part, you only did notarized part, but you have not done proper seizure. Then the police will come with the investigating agency of the manufacturer and seize the product from the concern where it is being stocked. For that also we have to follow very discreet method, because if the police is caught is noted from a distance and will come to case study, they run away. The product is also immediately thrown away here and there. In one case, the product was there with the individual for the last about 3 months. Some agency went there, got the product, everything was submitted. When the police went to seize the product on the basis of a report by the private investigating agency, no product was found. And therefore said, it is very wrong. We'll file a defamation case against the concerned agency. Why the police has been misled? So then, fortunately, somebody noted that under that shop, there was a nala running, and he had thrown that product into a nala, in the running sort of nala, and after some time, it was found that then people went inside, and in the presence of police, that product was brought out. So it was shown that no, he has not only infringed the product, he has not only been stocking the product, he is now trying to cheat the police also by throwing the product away after notice. In one case, another case I'll immediately give in 1 minute. In one case, a huge, I would not like to name for obvious reason, a very big manufacturer of certain branded sheets. And those branded sheets were being duplicated. And that particular chap, he was one of the big dealer in one of the biggest market in Chandigarh. And the agency was sure that the product is lying there, duplicate product. When the police was taken there, somehow or the other, no product was found, because that information leaked out that police is going to raid. So there was no product, no sheet found. But for the good luck of the agency, it went up on the shelves. On the shelf, they could get 2 sheets only, which were duplicated. Only 2 sheets, but it proved that this man has been keeping duplicates. Not a question of A or B or 100 sheets. The even keeping of 2 duplicate sheets is there that you have been keeping this product. And he could not produce evidence as to how these 2 duplicate sheets came to him. The police not only lodged an FIR, the case was filed in the court of law, and he was convicted.
When we get into our case histories, I think we'll be able to clarify these points for our audience in much greater detail. But I'd like to ask you another question. How can brand manufacturers obtain injunction, claim damages, and request the appointment of a local commissioner in civil court to combat counterfeiting?
The entire question refers to mostly the civil remedies. I told you criminal remedies is through police. The civil remedies, which are there in the Trademark Act, this entire question revolves around the civil remedies under which the court might appoint a local commissioner. In such cases, under the Trademark and Merchandise Act, the civil remedies involved are that you can do various things. You can obtain injunction and stay order from the court. What is the stay order? That so-and-so person is infringing my product. You go under the Merchandise and Trademark Act. We had discussed earlier, the Copyright Act has all cognizable offenses. Therefore, you could get to the Copyright Act cognizable. But the Trademark Act has only one section where there are cognizable, where the Deputy Superintendent Police can take the case cognizance. But all other offenses under the Trademark Act are the civil offenses. So in such cases, the civil remedies are involved. To obtain injunction and stay order from the court, it means that you have got sufficient evidence, not for filing as a copyright. It is not a cognizable loss. When we discuss copyright, I'll come to that. So it is in the civil injunction, he goes to the court of law. The court also gives order. All right, this particular man is in, and therefore, I'm not infringing. You come to the court of law and tell the trademark, you started, this is my trademark for 2 years earlier. I did not register myself. but I am producing the same type of product, identical to you. How do you say that I am? So their defense lawyer goes to the court of law. He says, no, no, we are not the infringer. So court goes on processing. The problem comes that in this process period, when the case is being fought in the court of law, that infringer goes on manufacturing its own product, goes on selling and getting benefit. So in such cases, the aggrieved party says, no, we must immediately stop injunction, that is further product manufacturing, but this infringer should not be there till he is able to produce sufficient evidence that he is the prior manufacturer in the Trade and Merchandise Act. So therefore, you go to the civil court, concerned civil court, and obtain injunction and stay order from the court. No, he will stay order. This infringer will not produce this product from day so and so as ordered by the court till the case is filed. Once the court has given a stay order, or top of it, if the manufacturer has been lost and so much money has been gained, so I give a degree up to this amount. It takes 6 months, 5 months to give a degree. So after that also, the question is, you have got a degree. You have also got some injunction for a stay order. Now the plaintiff, that is the person who has been aggrieved, he seeks order from the court for appointment of local commissioner. He says, I want some local commissioner because further investigation is not there. Trademark Act is all over. We have filed the evidence, what is there. He is still manufacturing, sir, and he is doing at this place, that place. You are given the injunction, but the process needs to be quickened. The local commissioners are appointed so that infringers are checked from further production of the infringed product. The local commissioner will keep a watch that further infringement is not done. And the same local commissioner appointed by the court can then swiftly take action to address the issues of not only further production, but also seize the infringed product under the local commissioner's order. The product which has been manufactured and which is alleged to be, they say this is alleged to be infringed. It is not infringed, but whatever it is alleged to infringe, court has given a degree. So therefore, what will you do is that seize the infringed product under the orders of the local commissioner. Then local commissioner can also further effective investigation been conducted under him and ensure some or other, not only the degree orders are facilitated, but also the accounts of the seizure of the accounts of the particular infringer also taken. So what happened? The court will appoint local commissioner who will keep an eye on that infringer, and the local commissioner will also get expedited that degree is executed. Over and above, the local commissioner will also ensure that in case further investigation is done, further investigation also he'll oversee. And at the top of it, he'll say the present till date, all the accounts of the infringer should be handed over to me. So overall, under the Trademark and Merchandise Act of the Government of India, these are the ways in which, except in one section under trademark, probably section 23, there the cognizable offense, if is taken under the cognizance, under the proper scrutiny of the deputy commissioner of the area, then it is permitted. But otherwise, it's a long, drawn-out process in the civil cases under the Trademark Act.
So now we've discussed the police action, we discussed the way to go through injunction processes. Now, in case as a product manufacturer, I have incurred losses because of the other person selling the counterfeit stuff of mine. In case I have to claim damages, in case I have to ask for money for the damages that I have suffered, how do I do?
Well, this all comes again under civil law. Total. Trademark Merchandise Act, once you file the case and you go ahead, then it's entire, all the civil law, the code of civil procedure will get into operation. It may take 1 year, it may take 2 years till you have filed the evidence and you say the money is given to him. Number of cases, the money has been recovered. But a number of cases it has gone on for years. But here you need a very competent lawyer by the manufacturer who should go on fighting the case. Then you can get the recovery. And that also is according to...
Very long drawn affair. And
very long drawn. So, sir, I submitted to you that is why when the manufacturers, particularly where the products are being counterfeited, or where the infringement was in respect of products which are ruining the health of the people, like medicines and all. In such cases, the people went to the government and went to the trademark authority that there should be some way where direct criminal cases should be filed. Then there will be some deterrent. So under the amended section 23 at that few years back, where they say, all right, if you think that there is really some such a case, that case cognizance will be given to the deputy superintendent. Not that means they somehow or the other that the officer of the police also should be of sufficient high rank who should recognize this case that really it is under the agree.
Now let's move on, sir, and talk of the economic challenges which are faced by manufacturers due to infringements and counterfeit.
Then we have discussed in the first also episode the huge economic losses, the huge financial over and above. They say the total cases they assess and they say that about 10% of the world trade has been taken over by the counterfeiter.
In your career, you've obviously encountered hundreds of these cases. And would you like to share some specific examples where the economic losses have been very heavy to the manufacturers?
You see, I already mentioned you that basically it's a fast-moving consumer goods. Like you may having oils, as I probably in the first episode I said also, that at one time the survey conducted by us indicated, collective survey, that there were 150 versions of genuine parachute oil, hair oil, which is going about or floating in the market. And it was said that an equal number, there's again about more than 150 versions or about 150 versions of Fair and Lovely cream are also being sold in the market. Similarly, Vicks Vaporub of Procter and Gamble company is having a huge losses is suffering because Vicks Vaporub is liked by everyone, but it's a duplicate product also in the market. Clinic Plus shampoo, Nike shoes, Unilever products, most of them, Gillette blades.
I would like to interject. Sometimes it's not only the duplicacy of the product, it is also the movement of genuine product from one territory to another territory.
Yeah.
And that because of the differential in pricing and so on. In which case the product is good, but the government suffer because of the taxes that they are that get evaded. And we'll be talking of these things when we do the case studies in later episodes. But before we end this particular episode, I'd like to ask you one last question, and that is, can you talk of the difficulties faced in filing an FIR in the absence of standard, well-known logos of various manufacturers?
Very interesting and very important. You see, we had the last question discussion was that it has to be the logo, boxes, etc. They should be identical. Then only you can file a case under Copyright Act. The very fact that the criminal case can be filed only when the standard design, coloring of that particular logo is identical to the logo of the original manufacturer, if you have to go under Copyright Act. Now the question arises, how will you establish that this logo belongs to so-and-so group? You go to the court of law, or first you go to the police station. Now the police station also says, okay, this logo definitely resembles the original, but how do you know that this logo which has been produced may have been registered by this particular party at one stage? They are using it. So it's very difficult answer for us to give for the police or the agencies investigating. So I'd only like to quote a very interesting case. In this case, what happened was that in one case, an interesting study was that one case, the product which was going about was a product for which the logo had not been registered by the particular company. But it was only that this logo belongs to us, and therefore nobody can get it. He says, you produce the registered logo of yours. If you say that product belongs to his original manufacturer, did not have any registration of that logo, did not have any stage of registration of logo. So how do you prove that this is your logo?
Now, I just want to tell everyone that we'll be doing several case studies on products that we have really done work on for protecting their brands from erosion. And we'll be talking of those case studies in subsequent episodes. And I'd again request you to like, share, and subscribe to our channel so that you can receive our videos as and when we put them on. As to conclude, I would say that brand infringement poses significant threats to businesses in India and across the globe. By staying vigilant, enforcing intellectual property rights, and fostering a culture of brand protection, companies can safeguard their hard-earned reputation and maintain consumer trust. Remember, investing in brand protection today is an investment in the future sustainability and growth of your business. Together, we can navigate the complexities of brand infringement and pave the way for a stronger and a more resilient marketplace. Ladies and gentlemen, I'd like to thank Mr. Sipal Singh for his his practical experience talk on this particular subject of combating infringements in India and the various laws that are available for our protection. Till we meet again, I'd like to thank you on behalf of NISSMAT that please do like, share, and subscribe and listen to our podcast as often as you possibly can. Thank you very much.
Thank you indeed. Thank you, Pawanji. Thank you very much.